Under a contract, Edwards agreed to sell and Lysaght agreed to buy a mansion in Bedford in England for nearly £60,000. That's nearly 17 million Australian dollars in 2024. A deposit was paid and there were things that the seller had to do before the purchase could settle. During that interval, unfortunately, Edwards, the seller, died. Under his will, a complicated set of gifts and dispositions were made, many of them involving the mansion and its grounds. So, do they execute the contract, which means ignoring the will, or do they execute the will and breach the contract? Is the contract frustrated? Do they have a choice or an obligation? Master of the Rolls Jessel's judgment has become the classical expression of the law. He said, "The moment you have a valid contract for sale, the vendor becomes in equity a trustee for the purchaser of the estate sold, and the beneficial ownership passes to the purchaser, the vendor having a right to the purchase money, a charge or lien on the estate for the security of that purchase money, and a right to retain possession of the estate until the purchase money is paid in the absence of any express contract as to the time of delivering possession." In other words, as soon as there is a contract for sale, the seller no longer has full ownership of the land, but instead holds the land on trust for the buyer until the buyer either pays the purchase money or breaches the contract. So the land and the mansion could not be passed under Edward's will because he was only the trustee of the land when he died and not the beneficial owner. The Master of the Rolls reached this point by reasoning by analogy. He based his analogy on the rights of a mortgagee. A mortgagee does not own the property subject to a mortgage. They merely have the right to insist on being paid and to use the property as security for that payment. Similarly, a seller no longer owns the property as such. Rather, they have a right to insist on being paid and to use the property as security for this payment. From this case, we learn that from the moment that a contract is executed in writing for the sale of property, the seller holds that property on trust for the purchaser.